Bismillah Rahman Rahim. Welcome to Law Junction platform. Today I will discuss an act of 1926 about the good condition of the prisoner on probation release. The name of this act is the Good Conduct Prisoner Probational Release Act 1926. Now I will proceed the text of the act. An act to provide for the release of good conduct prisoner on condition imposed by the provincial government. Preamble. Whereas it is expedient to provide for the conditional release from prison of good conduct prisoner in certain cases before the completion of the term of imprisonment to which they have been sentenced, and whereas the previous sanction of the Governor General under subsection 3 of section 80A of the Government of India Act has been obtained, it is hereby enacted as follows. Section 1, short title, extent and commencement. Section 1, subsection 1. This act may be called the Good Conduct Prisoner Probationer Release Act 1926. Subsection 2, it extends to the whole of province of the Punjab except tribal areas. Subsection 3, it shall come into force on such date as the provincial government may by notification appoint in this behalf. Section 2, power of government to release by license on conditions imposed by it, notwithstanding anything contained in section 401 of the Code of Criminal Procedure 1898, where a person is confined in prison under a sentence of imprisonment and it appears to the provincial government from his antecedent or his conduct in the prison that he is likely to abstain from crime and lead useful and industrious life. If he is released from prison, the provincial government may by license permit him to be released on condition that he be placed under the supervision of authority of servant of the state or a secular institution or of a person or society professing the same religion as the prisoner named in the license and willing to take charge of him. Explanation of above section. The expression sentence of imprisonment in this section shall include imprisonment in default of payment of fine and imprisonment for failure to furnish security under Chapter 8 of the Code of Criminal Procedure 1898. Section 3, period for which license is to be enforced. A license granted under the supervision of Section 2 shall be enforced until the date on which the person released would, in the execution of the order of warrant authorizing him imprisonment, have been discharged from prison had he not been released on license or until the license is revoked, whichever is sooner. Section 4, period of release to be reckoned as imprisonment for computing period of sentence served. The period during a person is absent from prison under the provision of this act on a license which is in force shall be reckoned as a part of the period of imprisonment to which he was sentenced for the purpose of computing the period of the sentence and for the purpose of computing the amount of remission of his sentence which might be awarded to him under any rules in force relating to such remission. Section 5, form of license. A license granted under the provision of Section 2 shall be in such form and shall contain such conditions as the provincial government may by journal or special order or by rules made in this behalf direct. Section 6, power to revoke license. Subsection 1, The provincial government may at any time revoke a license granted under the provision of Section 2. Subsection 2. An order of revocation passed under the provision of subsection 1 shall specify the date which effect from which the license shall cease to be in force and shall be served in such manner as the provincial government may by rules prescribe upon the person whose license has been revoked. Section 7. Release absconder who escape from supervision to be punishable. Subsection 1. If any person escapes from the supervision of authority of a servant of the state or secular institution or a society or a person in whose charge he has been placed under the provision of the Section 2, or if any person whose license has been revoked under the provision of Section 6 fails without lawful excuse, the burden of providing him shall be upon him to return to the prison from which he was released on or before the day specified in the order of revocation. Such person shall, on conviction by a magistrate, be punishable with imprisonment of a term which may extend to 2 years, or with fine, or with both. Subsection 2. An offence punishable under the provision of subsection 1 shall be deemed to be a cognizable offence within the meaning of clause F, subsection 1 of the section 4 of the Code of Criminal Procedure 1898. Section 8. Power to make rules. The provincial government may make rules consistent with this act, subsection 1, for the form and condition of license on which prisoners may be released, subsection 2, for defining the power and duties of government officers, societies, or person under whose authority of supervision conditionally released prisoners may be kept, subsection 3, for defining the classes of offenders who may be conditionally released and the period of imprisonment after which they may be released. Subsection 4. Generally, for carrying into reflect all the purpose of this act. This act is called the Good Conduct Prisoner Probational Release Act 1926. This act is very short, but it is highly used for probation in the prison of Government of Punjab under the working of Government of Punjab in the Punjab province. In next lecture, we will proceed to another act which is based on the procedural laws of the country. Stay tuned with us.